Sorry about that, everybody. Okay, hello and welcome to our webinar today. We're going to be looking at sexual harassment and give particular focus to the party season that we are in. So we're going to make a start. I hope you're ready and sitting comfortably. So a warm welcome to you all, and I wonder what any of you thought of my lady in the yellow dress there. I hope you'll all agree that she is standing very innocently on that bridge and has every right to appear as she does and to deserve respectful treatment. And if you don't, please send through your questions as to why, because we probably need to have a bit more of an in-depth chat than we can cover off in this webinar. Okay, so as always, we'd like to start with some introductions. My name is Karen Lovell, that's me there. I'm the HR Knowledge Manager for HR Solutions, so I shall be your lead presenter today. And I am joined by my colleague Atim. She's here just to field any technical problems. Hopefully there won't be any. And she'll be monitoring any questions that you might have. So please do send through some messages for us. If we have time at the end to answer any questions that might be relevant to most, then we will look to answer them. But otherwise, if you send through the email anyway, I'll personally try and come back to you after the webinar as soon as possible. So we will be recording this session and slides will be made available on request afterwards. So this is the structure of the webinar today. We will have an overview, so we'll get the legal bits out of the way, and then we'll look at some top tips, fear reporting, handling a complaint, and some common problems. The reasons why I've chosen those areas are because I'm hoping that we can achieve the following for you. So by the end of the session, you'll hopefully have an understanding of an overview of the law that applies in this situation. We'll try and take some learning from current issues and also test cases that have come out. We'll try and give you some ideas and quick wins that you can put into place to prepare for your work parties. Hopefully you'll feel a bit more confident about what to do should somebody make a complaint. And also just want to give you some tips on ways to address the issue of people being fearful of reporting. I'll explore that a little bit more, of course. And then we'll wrap up by looking at some common questions really that come up on our helpline in case you've ever had them and have wondered what you're supposed to do. So we'll try and steer you in the right direction to avoid them altogether or how to deal with them if they should come along. So an overview. Well, first things first, okay. Harassment is on the grounds of a protected characteristic. And in this case, it's going to be sex and it could be orientation as well, okay? So this is the piece of law that we are talking about, separate to the Employment Rights Act. I hope you all notice. So both workers and employees are protected against harassment, and that's because it's a discrimination issue. It's not covered in the Employment Rights Act. But this also means, of course, that any self-employed people you might have coming in and any prospective employees and so on would all be able to bring civil claims of discrimination as well. Okay, so those people could bring a civil claim in a civil court, but our employees and workers could potentially bring a claim in an employment tribunal. So harassment, I think it is important we look at the definition. Quite often people think harassment is, repeated attempts to try and badger somebody, but actually in discrimination terms, harassment can be a single act of unwanted treatment that may degrade, humiliate, offend, or intimidate another person. Okay, and it's characterized by violating somebody's dignity. All right, so it's a single act, which quite often people don't realize. So treatment of this nature is unlawful. And I want to also just acknowledge here the close cousin of harassment, which is victimisation, a term often misused on the advice line. We get many people calling us and saying, my employee is accusing me of victimisation, you know, or it's littered throughout a letter that they've written in. They often mean that they're being victimised, or that, well, they mean they're being targeted, I should say. I don't want to be in danger of getting it wrong. They mean they're being targeted, you know, or in many cases, actually, they're just being managed. But victimisation, actually, in this legal context, means that they've suffered detrimental treatment, okay, because they have supported or made a complaint of discrimination. Okay, so it's actually very specific. It's because you've already made or supported a complaint for discrimination. So, headlines. I'm sure we've all seen some of the shocking headlines, many celebrity names that are coming out of people who we just would not expect. It just seems to be happening all the time at the moment, that new names are being revealed to us, and it is shocking and it is alarming and it is incredibly disappointing. These are some headlines that I've actually pulled out of the press, though, in the last few days, just to demonstrate even more, you know, how repetitive and current this situation is. Ones I've picked out as well are ones that I think are actually probably related to work. So you might not necessarily think about cabinet ministers having anything to do with work, but people work there, you know, and if they're sat at their desks watching pornography, this can be treated as a harassment issue. And quite rightly, a poll has found that that's how people would like it being dealt with, you know, as a potentially gross misconduct matter. Equally, the NHS is being named as an employer under which harassment has happened. Fashion models working in that industry are going to be experiencing harassment as well. And some quite alarming figures suggesting that 1 in 5 women have been sexually harassed in the workplace. Now, in my view, and it is just my view, but I think that the way things have been in the press at the moment shows a few things. So other than the, of course, alarming magnitude of the problem, I think what we're seeing is that, well, A, people accused of these offences are people you might not expect, okay? There is no perception, you know, that we should look to generalize as a person who might do the harassing, and equally, you know, be a victim of harassment as well. I mean, you've got some incredibly famous film stars and actresses who you might not think as, you know, a victim per se, but have come forward and being brave and saying they have been affected. So firstly, you know, there's not a type of person that you're looking out for here. It could be anybody. Secondly, what seems to be incredibly sad is this fear of reporting. You know, the hashtag #MeToo seems to have encouraged many people to come forward, but it only seems to have happened as a ripple effect, you know, to 1 or 2 being brave enough to do it. And actually, many of the issues that we have heard reported have happened in the course or connection with employment. Again, you know, these celebrities, they're still actors and actresses trying to get a job, trying to get work, and it's happening in the workplace. So let's just think about what harassment might look like then. Well, I didn't want to give any, you know, examples that were of my opinion, but ACAS have actually recently updated their website, and they've given these as examples of harassment. I think many people know now that it's not something as deliberate or explicit as a sexual assault, but can also include verbal comments, offensive jokes, displaying explicit images, content in emails of sexual nature, and unwanted contact and touching. Now, it is of course the case, though, that some types of harassment are going to be a criminal matter as well as an employment matter. Anyone who feels that they have been assaulted in a way that is criminal should contact the police. In the workplace, and in fact generally really, the ultimate test of whether or not a person receiving treatment has been harassed or not will really depend on whether or not that conduct was unwanted. Okay, that is a really key word, whether or not it was unwanted, because this actually means that some behaviours might not be harassment in one context, but could be harassment in a different scenario. So, for example, a colleague touching somebody's arm, if those two are friends outside of work, that might be absolutely fine. But another colleague touching the same employee's arm in the same way may well be harassment. So you might feel like this is a bit of a can of worms, actually, because, you know, how somebody perceives an act can be subjective, and you're absolutely right. We've learned here that actually the view of the person who received the treatment is the one that counts. Okay, if any of you are interested in more of the legal side of it, there has been a test case, Heathfield versus Times newspaper, in which the tribunal did determine that actually the employee wasn't reasonable to have taken offence, given the context of the situation. So we do have some ground upon which we can say, all right, steady on, I think you're being overly sensitive there. But I really don't want to dwell on this much, because I don't want anybody to think we could rely on this case as defence for not having taken precautionary measures or necessary action, you know, because we feel that the employee is being too sensitive. Okay, we really have to look at it objectively and think what an everyday person might think about the circumstances. Now, a poll has been carried out by Opinion Research, and the research revealed that 58% of women who have experienced sexual harassment did not report it to their employer, okay, which is really quite alarming and really quite sad. There were polled that men have experienced sexual harassment at work as well, but that was about 7% of the men that were polled who reported having received sexual harassment. So I'm just going to dwell here a little bit longer, so bear with me, because I did say that we were going to think about some cases, and I think some of them give some quite interesting examples as well. So there was a case where a heterosexual employee was called gay, and he won a harassment claim. Okay, so this is Austin versus Samuel Grant in the Northeast. He was asked whether or not he liked football by his colleagues, and when he told them that he wasn't particularly interested in the sport, his colleague said, "Oh, well, you must be gay then." He raised a grievance. The HR director rejected the grievance, saying that this was just banter and it's common in football circles. So, interesting. We have another case that looks at banter, which I'll just discuss before exploring that dangerous word. There was also another case where an employee was subject to harassment because she kept experiencing banter in a similar vein to the Carry On films. Okay, so she was spoken to in a way where she was receiving remarks daily in a theme of the Carry On films. It was of a sexual nature. It was suggested that this was just, you know, common in the workplace, you know, as was the use of strong language, and it was just an everyday fact of life for somebody who worked in this organisation. And this case was Minto versus Wernick Event Hire.
And so actually what Tribunal has said about banter is that banter can be a loose expression, which I think we could probably all agree with, which can cover what otherwise might actually be abusive behaviour on the basis that those participating do so willingly and on an equal level. So if actually it could be interpreted that maybe these people didn't really have much of a choice in the banter, and actually if it is a culture that they weren't partaking in and had to endure in order to continue working there, then they effectively had no choice but to put up with harassment. And then we have more, explicit cases, one being Furlong versus the BMC software company. The senior vice president actually told a female colleague that he would like to eat her like a marshmallow. She was described as having been having relations with a married colleague, which she was not having. She was also groped, and she won numerous claims, including direct sexual discrimination and harassment for that treatment. So that's the heavy bit out of the way in terms of the legal side anyway. So let's try and lighten the mood a little bit. I want to think about your festive parties that you might be planning, or end of year parties, if that's what you're calling it, because remember, not everyone celebrates Christmas. And I just thought it would be a great idea to have a look at some really quick wins that you could put in place just to try take responsibility as an employer to minimise the risk of sexual harassment at work. So might seem a bit jokey, but there is obviously a serious undertone to them. So number one, don't decorate with mistletoe. It can make some people feel really uncomfortable, and you just don't want to be advocating forced contact. So take that down if anyone's put it up. Discourage games that may incite sexual inferences, jokes, touching, or gender segregation. Okay, so I'm thinking Twister, passing balloons or objects with just your legs, or making teams for boys v girls, okay, because these could all encourage someone to make inappropriate slurs or gender slurs that could get out of hand, particularly if there's alcohol involved. You know how it is. So I know it's typical of HR to be seen as, storming in and spoiling the fun, but there are other things that we could play. Photo booths are really common and really popular at the moment. So if you're hiring one, fab, but let's make sure you're using appropriate props. Make sure they're U or PG rated and Christmas friendly. A friendly reminder email. Now, isn't it great when you get a friendly reminder? But honestly, probably a really good way actually just to remind everybody that actually at a work party, you are still expected, to be respectful to your colleagues, and actually as well that we can still monitor and even take action against inappropriate behaviour that you commit or do whilst at a work party. Okay, we have got case law to back that up, particularly, a party that has been arranged with work. Interestingly, if somebody goes on to a second bar, afterwards of their own accord, that might start to become a civil situation. But a work arranged party, we can still monitor conduct. We do still have responsibility for everybody's safety there. Okay, and I've highlighted reasonable expectations because if you are arranging your party at a bar or a restaurant that serves alcohol, again, we're going to have to expect that people's inhibitions will be lowered if they're consuming it, and that's fine. We should expect some drunken antics, but it is never an excuse to not treat somebody with respect or to discriminate against them. So in that same friendly reminder email, you might just want to add some, local numbers of taxi ranks or hotels if people are staying particularly far away, so that everyone's prepared to get home safely. Certainly lingering on the streets, just outside, trying to blag a lift or so on is an opportunity for risks to manifest themselves. If you have got any social policies, just dig them out and remind yourselves of what they say. You might have some useful phrasing in them that you can use in that email, but you might also have some specific nuances to your business, and it's well worth remembering what they are, and even reminding them to your staff as well in that email. On a more serious note, don't make the mistake of thinking that we're only talking about protecting, women here. So let's avoid things like naughty Santa outfits or rude cards and so on. If you see any, groups of ladies getting a bit over the top, at the Christmas party with a poor guy on his own, whether he's sexual or not, consider a rescue mission, wade in, go over. If you're a senior manager, just walking over might just inhibit some of them with your presence, and you're just gonna, reduce the risk of anybody saying anything inappropriate. All right, so I hope that was helpful. I hope you've got a couple of ideas there that you could go and put in place this afternoon. But more long term, as I said before, we've got a real problem with people fearing reporting sexual harassment, which is really troubling. And as I said, I think it is something that's happening more often than not in the workplace, really. And what do you do about it? Well, it's great if you see it, but it might not always look like these images on the screen. Sometimes it's a lot less explicit and something that you might see more often. It might look like this. Okay, and it's really sad. But we need to make sure that we're reaching out to people who may be experiencing harassment and trying to get them to report it. And so I've been sitting and thinking, and I've come up with 8 tips that I think are things you either should be doing or should get in place if you want, or might just change your practices in a way that means that you can feel confident actually you're taking some responsibility to try and deal with this problem. So, number 1, publish a zero tolerance statement and circulate it to all of your staff. Okay, many of us have got an equal opportunity statement and we should have one, but if you just write it, leave it in a folder or publish it on your website and never practice it, don't actually know what's in it, what use is it? Get one that you're proud of and sell it to everybody internally. Number 2, staff should know 2 senior people they should confide in. Okay, most people probably would go to their line manager if they have a problem, but very frequently the problem is with the line manager. So what do people do? Well, if you do have a policy that says what to do about harassment or grievance, hopefully you have a section in there that suggests another person in the organisation who you would suggest staff go to if they have an issue. Preferably, you would have, another department, for example, in association with a different one, who staff feel like, well, if something happens to me in my department and I don't want to speak to my line manager, I can go to that department and speak to a member of staff there. So I mentioned policies. Have a reader-friendly harassment policy in place, okay? A bit like your statement, it's all well and good going to HR and them providing a policy, but at the end of the day, a few sheets of paper saved in an arbitrary file that's never looked at isn't going to protect anybody. So firstly, make sure you have one, and I would suggest that you have a harassment-specific policy. Make sure you have one. Make sure everyone knows that you have one as well. Bring it up in meetings with line managers. Check that they know where it is. Make them check that their teams know where it is. And why not ask for views, and suggestions to enhance the policy from staff, so that everybody's getting involved in the very policy that's there designed to protect them. It should be reader friendly. So I'd suggest, if you haven't read it for a while, take some time just to sit down with it and put yourself in the position of somebody who could be in distress. Okay. Is it reader friendly? Does it set out clear steps which somebody feeling distressed will feel are achievable to them? Okay. A point to note here is I see many policies that say if we become aware of harassment, then this may be treated as a gross misconduct matter. You will be subject to our disciplinary procedures and you may be summarily dismissed. Now, where that is quite right, if the harassment is gross misconduct, I would suggest to you that that is probably going to discourage somebody who feels that they have been harassed from reporting it. Someone's only going to read that policy if they feel that they are being harassed. A harasser is unlikely to pick up that policy, to check whether they're acting within, the correct means that's going to be tolerated by a company. And so you should just look to put potential outcomes of somebody who is a harasser in a disciplinary policy instead, would be my suggestion. Adopt an open door approach. Maybe this sounds really obvious and it might sound something that's really easy to do and you don't give it a second thought, but I really mean it, adopt an open door culture. Encourage employees to speak with their line managers. Any opportunity you are communicating with staff, suggest that they speak to your line manager and really get the line managers on board with that as well. Actually open your doors, leave them open all the time unless you really have got something private when you need to shut it. If you get into that habit, people will understand when they are welcome to walk into your room and when they aren't. Sounds like a little thing, but I think you might find it would really help. And also, the more that people do walk in and out of your office, the less obvious it might be when someone's going in there with a serious problem. So my fifth one is about raising awareness. So you might have a statement, you've got a policy, you've told everybody where it is, but I think it's going to be really important that we try and advise staff about sexual harassment, give them examples, and explain to them, what they should look to do if harassment happens, so that, if anything, they just know to go to your policy, but might have an idea about what to expect as well. So this touches on my next point, training, and I'll discuss it a little bit more there, but it's really, I suppose, about creating a culture of respect. Okay, if you raise awareness and raise respect within your organization, you're not only going to discourage inappropriate treatment, but it's also going to make any disrespectful behavior really stand out as well. So be talking about it regularly. If you're discussing promotion strategies or planning office parties, use it as an example whenever you're thinking about, am I living up to my equal opportunities statement, and talk about harassment. 6, as I said, training for both managers and staff so that they can recognise harassment, deal with it effectively, and avoid being a perpetrator inadvertently. I doubt many people set out thinking, I'm going to perpetrate sexual harassment. They probably do it without really realising. Not an excuse, but if we can prevent people from doing it who might not have realised something is harassment, then let's do it. I've got some recommendations. I would think about trying to find some training that will focus on practical behaviours rather than learning about harassment. Many people know about harassment these days, or at least they know that it's not as crude as groping somebody, for example. They tend to know that it can include verbal comments as well, and that everybody should be treated equally. You know, that's parroted to as quite a lot. But where people fall down is that they don't actually understand what this means in practice. So if you can find training that focuses on behaviours in the workplace, that looks at what you should do as much, if not more so, than what not to do, people tend to engage with that better. Try and avoid using labels like harasser or the victim. I've tried to avoid using those words in this webinar. Sometimes I have to because it's exactly what we're talking about. If you try and avoid labels of harasser and victim, because people tend to see these as labels, and labels that they do not associate with themselves. You know, harasser, that's someone else, that's not me. Victim, that's somebody else, you know, that's Joe Blogs, that, you know, what happened to them last week, isn't it awful? I'm not a victim. So try and avoid those labels where you can. Try and make it real to an individual. And my last bit of advice on this bit, which I've put there on the slide, is about changing the attitude of bystanders. So I think people tend to feel that it's easier to defend somebody else rather than yourself. Okay, don't know what you think or if you agree, but I tend to see that as the case, and it's probably far more likely that inappropriate behaviour would be reported by your staff if somebody who witnessed it could come forwards rather than the person it happened to. You know, so if we try and enable a bystander to feel that they too can inform a line manager or whoever it might be that they've seen harassment, I think you might uncover more problems. Equally, if you enable the bystander to think about, actually, you can walk over to someone who you feel you've just witnessed being harassed and ask them if they're okay, ask them if they want support reporting it, or just reassuring them that actually what I've seen wasn't okay. So if you don't feel comfortable with it, then I would encourage you to report it as well. It's really going to help, and I think this is probably a key group in the scenario of harassment being played out, that we could try and unlock to get more reports of harassment known to us so we can deal with them. Okay, number 7 is explore unexpected resignations. So we quite often get calls saying, oh, such and such has resigned, and we don't really know why. Let's find out, because what if they're resigning because they've been subject to harassment, or indeed any serious workplace issue. Staff only really tend to resign from their position if something's wrong, if they're not happy where they are. Don't get me wrong, there are positive reasons to leave as well. If there just isn't development opportunities left in your business for someone anymore and they've been offered a fab position somewhere else, then that's great, or if they relocate, for example. But otherwise, resignations are something that come about because employees aren't happy. So if you get one and it's either totally unexpected or you suspect that the resignation is related to something, untoward, then give your employee a cooling off period. And I'd strongly suggest that you put this in writing as well. Okay, so say it verbally, let's be human about it, but also put what you've said in writing so that you've got evidence that you have said, look, give me an opportunity to understand what's going on and to try and put things in place to keep that person at work. Okay. This is always going to be something that is recommended if you're dealing with sexual harassment, and it's something that's always going to be recommended if you're dealing with somebody who's got more than 2 years service and is what's called a qualifying employee. Equally, if you've had to discipline somebody in connection to sexual harassment and they resign, it's still well worth you asking them to have a cooling off period, to understand the reasons why you've had to take disciplinary action, and ask them to reconsider. Now, if they're resigning because they felt that the process was not fair and needs review, and you've not had an appeal, then consider offering an appeal, particularly if they are still within the timeframes set out in your original outcome letter. And lastly, my last tip is to look into stress-related absence. So if any of you are well practiced in HR, you'll know this is something that we look to do by default anyway. So regardless of whether you get, a sick note, or even if you get a sick note that just says stress and doesn't say work-related stress, I would strongly advise that you pick up the phone and just ask how that person is and what they think the source of the stress is. Now, of course, they don't have to tell you, but if they're going off with stress and you've got no clue what's going on with them, act as though it could be something at work and find out what it is, okay? So, hopefully, we have done what we can to try and minimise the Christmas party or end of year party going awry. We've put in place some things that can try and encourage staff to come and talk to us about an issue. What on earth do we do when that one comes in? Well, let's encourage staff through the door. So I've already mentioned this, but I can't emphasize it enough. Make it obvious that you want people to come and talk to you. Invite them in. This is a trusted environment where we're going to respect what you've had to say, respect you as a person as well, and not think less of you for having been a victim of harassment. And actually, we're going to really try and do you a service here and deal with it for you. Okay, so look to do that. Familiarise yourself with your harassment policy. As I said, I would strongly advise that you have a specific harassment policy in place. It's very good practice. But if you don't, then you could use your grievance policy instead. Just be cautious, though, that a worker cannot raise a grievance. If you allow a worker to raise a grievance, you're potentially risking them having employee status instead. Okay. It's not to say that you shouldn't still look to deal with the harassment, but you shouldn't follow your standard grievance policy. Now, if you should have neither policy in place, then get them in place now. Give us a call. Let us help you with one. It's just a really quick measure, actually, that you could roll out. There's no excuse for it. But if you are caught short, then in all seriousness, please refer to the ACAS Code of Conduct. Indeed, we should all be referring to the ACAS Code of Conduct. After all, any successful claims in tribunal that are seen to have not adhered to the ACAS Code can have awards uplifted by 25%. Okay, so there's no excuse. It's free, it's available on the internet. We just have to Google ACAS, dig it out. Now, once you are aware of an issue, managing it closely should be a top priority, okay? I know that you might have a lot of important things going on, day-to-day runnings of your business that actually you feel take, prevalence, but this could potentially be a significant downfall. You don't want to land yourself in a tribunal situation. It could be incredibly costly. You will wish you put time aside to deal with it, so please do. And a paper trail is vital. Now, please notice that I have not only put that in bold, but I've also underlined it because I cannot stress enough how important a paper trail is. Okay, now I don't feel like I'm a heartless person. Of course, actually resolving the issue for the employee is the most important thing, okay? But don't let all of your hard work and best efforts go to waste by not having documented any of it, okay? Because if they still take you to tribunal anyway, which they can do, and you've got absolutely nothing to show for it, where's your defence? Okay?
A tribunal will always, without fail, take the paperwork of a case and read it before even asking you a single question. And in fact, they don't have to ask you any questions if they don't want to. Okay, so don't assume that you will be able to justify your actions. You need evidence of everything, okay, which is why we're always, you know, going at you to try and follow up things that you've said in a letter where appropriate. Okay, so please do that. So practically speaking, you've got this employee, they're sitting in front of you, they've managed to get through the door and they're saying, I'm feeling like I've been sexually harassed at work. Okay, what do? Well, you need to immediately assess the severity of their allegations. Okay, this will help you to determine whether or not it's necessary to suspend the accused person right then and there, if possible. Okay, you should explain the process that you intend to follow to the individual making the complaint in accordance with your policy, of course, and this should reassure them and just help to manage their expectations going forwards. Okay, you don't want them coming back to you saying, what are you doing about this? Tell them from the start what you intend to do and keep them informed. Now, you do have a duty to follow your policies. You must follow them if they are contractual policies, but why not ask the employee if they're comfortable with your intended approach? Okay, I mean, find out what their ideal outcome would be. This will help you to ensure that actually, you know, your time and effort is not wasted and that you don't get to the end of it and in the, you know, eyes of the employee, you haven't sorted it out, you know. So ask them what we're aiming for here and follow your procedure with that end goal in mind. Now, whether or not the person does want you to take action may be irrelevant, okay? You do have an immediate duty of care to protect them from any further harassment or from victimisation. This means that you will still need to take steps to investigate the claims thoroughly and to take an appropriate level of disciplinary action if it is required, okay? Now, on that note, if you have had some initial examples, and particularly so if you think that the examples could be gross misconduct, then try and have a preliminary investigation meeting with the accused before they next work, okay? Potentially, you never know, they might be able to give you a fantastic reason that renders any further action against them, you know, unnecessary. You know, let's say you ask them to relay what happened, you know, anything significant that happened on the, you know, the 22nd of December, I'm trying to think if that's a work day or not, the 22nd of December, anything unusual happened that day, and they say to you, I was on annual leave that day, you know, and you think, oh, crikey, yeah, and you check the rota and they weren't even in the business, but the person that's come up to you has said, you know, I'm not sure who, I think it was this person, but they've touched me inappropriately, it was on the 22nd of December, well, you know straight away it's not that person you've sat down in an investigation meeting and that you need to look elsewhere. I touched on this before. Do build plenty of time into your schedule, and it might be that your colleagues need to too. It's probably likely, if not inevitable, that you'll be running both a harassment or grievance policy in conjunction with a disciplinary policy as well. Both of these processes need you to minimise undue delays as far as reasonably possible, not only for procedural necessity, but also because you just need to be trying to minimise the level of stress that's going to be endured by the person that's raised it and the person who's potentially sat at home on suspension. So your colleagues might need to build in time as well, because of course, hopefully we all know that an informal stage of either of these processes cannot be ran by the same person that you intend to run the formal stage, okay? The formal stage must always be conducted by somebody of senior hierarchy or the same level of hierarchy or seniority. If it's appropriate, you could try going down the informal route first, okay? Because don't get me wrong, I for one know that as soon as you make something formal, it makes it almost impossible for the people involved to have, you know, a good, positive working relationship going forward, you know, certainly in the short term anyway. So if an informal approach, you know, could be appropriate, let's say the misconduct is just that, it's misconduct rather than serious or gross, then potentially you could go down this route. But do not deter a person from choosing the formal route if that's what they want, okay? You can just offer it as an option. They might not realise it was an option, suggest it. It can help. If you do have an informal meeting and you still have to go to a formal route, then fine, but repeating that step can be a really great idea as well once you're at the end of a process, because you can just try and, you know, discuss some constructive ways, you know, of which we're going to move forwards in a facilitated meeting. And lastly, you know, it might sound obvious, but please see all your procedures through to completion, okay? You don't want to be caught short of a breach of contract if your procedures are contractual, but offering an appeal does just help anybody, again, who might still feel that they've not been treated fairly, to have a second chance at overcoming the outcome. So let's just have a look at some common problems and questions that we get on the advice line here about sexual harassment. Hopefully some of them are things that you've experienced, you know, and I can help, you know, assure you or reassure you as to whether or not you did the right thing, or it might be questions that have come up in your mind through the webinar. So let's have a look. Should I tell the accused? And if so, when? Well, okay, in true HR fashion, it's not a straight answer. A balancing act is going to be required. Okay, so if a formal route was necessary, this is going to point you to the requirement to have a formal meeting with the person that raised the complaint. This is going to mean that you have to issue a written invite. You're going to have to give sufficient notice of the meeting. You're going to have to offer the right to be accompanied to that meeting. And we all know that the right to be accompanied also comes with the right to delay a meeting if the representative isn't able to attend, you know, and we can rearrange it within 5 working days. So potentially, you know, you might not get to be able to sit down with this employee for a number of days after they've raised the complaint if we're going down a formal route. And this formal meeting should be held before you have a full investigation with the person who's been accused. So if you're setting up that meeting, you would wait until after you've held the grievance hearing. But then you might be thinking, okay, but what if I suspected gross misconduct? Because you said before that I have to suspend a person, you know, immediately. Well, yes, you're absolutely right. And of course, if you did not suspend a person immediately or put other measures in place to the effect of suspension, then this could render any gross misconduct dismissal that you might eventually make as procedurally flawed. So what on earth to do? Well, this is why, if you remember, I did mention previously actually that if you have a preliminary discussion with the employee and try to get some really specific examples of the worst behaviours that they've experienced. You know, you're not asking for chapter and verse, you're just saying to them, look, I know this might be hard, we will discuss it in more depth at a later point, but for now, so I can understand the gravity of what we're dealing with, just give me a brief description of some of the worst things we're talking about here. And you can then decide at that point whether or not it sounds like you could be dealing with gross misconduct, okay? If you think it could be, if you're not sure, that means you think it could be, then have an equally preliminary investigation meeting with the accused, okay? Because again, they might be able to give you quick, clear mitigation straight away, and you know, it's sorted. But if you're unsure, you've got to remove them. So what is the answer to the question, Karen? Well, should I tell the accused? Yes. And you should tell them at the point which you are concerned that this is gross misconduct. Okay. If not, wait until after you've held the formal grievance hearing, or if you manage to go down an informal route, agree with the employee who raised it when to speak with the accused. What if they don't want me to tell the accused? Okay, well, if there's no doubt that they're being sexually harassed, then you will be obligated to investigate anyway, okay? If the person reporting the harassment is uncertain as to whether or not they are being harassed, I'd strongly suggest you just sit down with them, explain what constitutes sexual harassment, and then ask them to tell you what has actually happened, you know, and whether or not that was unwanted conduct, okay? Might be quite a sensitive conversation to have, but sometimes it's difficult to tease apart, you know, a flirtation with someone who you feel that you might have been, you know, giving signals back to, for example, or whether or not it really crossed the line. So just try and have a sensitive conversation. If they choose not to tell you the specifics, okay, or they wish to go away and think about what you've said and whether or not it did make them uncomfortable and it was unwanted, then okay, agree not to speak to the accused. But please arrange to have a catch-up meeting with them. Don't just propose it, put it in their diary so that you can, you know, see how things are going. If they've worked up the courage to come and speak to you about it, it probably is an issue that needs addressing in some way. And again, if they do give you examples, if they weren't sure and they do give you examples and you're sufficiently concerned about behaviour, then again, you have a duty to act regardless of what the employee says. So if they have given you examples that are misconduct, then you do have a duty to investigate and talk to the accused person about it. And how do you then manage the relationship between the two parties? Well, it is tricky. If it was potentially a gross misconduct situation, of course, though, you've probably already ascertained whether it was necessary to suspend or remove that person. When I talk about suspension or removing, you do need to consider alternatives to suspension. As I may have mentioned before, you just need to consider whether or not it's possible to perhaps ask that person to carry on doing that work from home, for example, in a place where they can't potentially harass your staff. If you didn't need to suspend, I'd ask the employee who raised the complaint for suggestions. You know, why not ask them what's going to make them feel more comfortable, because who knows better? And then just consider whether or not that's feasible. So speak to the person that's struggling to cope and see what you can put in place. Now, they might suggest things like moving desks or changing lunch break or working a different shift, and that's all great. You might feel like, well, actually, if it wasn't them who did the harassment, you know, I'm going to change the desks of the person who is suspected of doing it or change their lunch break, but don't. Okay, it might feel unfair, but if you take any measure that might seem punitive against the accused before full disciplinary has taken place, then that might seem as though you've predetermined the outcome. Okay, so as above, you know, speak to the person that raised the complaint. You can speak to the accused as well if they're also sat there feeling really awful, but please try not to take any adjustments without the agreement of the accused anyway, if that's what you intend to do. I can see I've hit my hour, but I'm just going to do this last slide because you might be interested about what you should do if an allegation is found to have been made maliciously. Well, this is actually rare that anyone makes a really malicious claim of sexual harassment against somebody in order to get them into trouble, but it does happen, and exploiting a system that has been put in place to protect a vulnerable person is absolutely wholly unacceptable, okay? And not only that, but it undermines genuine traumatic experiences, and it could in itself constitute an act of bullying, which I hope will be something that is listed as a potential gross disciplinary offence under disciplinary procedure. And so if it is found to be both false and deliberately malicious, you know, and is subject to the criteria for gross misconduct allegations and the key principles of gross misconduct, then you could potentially summarily dismiss somebody for raising a false allegation, okay? But it is rare that it is made without any glimmer of a suggestion there, okay? So if a claim is also made sincerely, but you just don't find any evidence to substantiate the claim, as does happen quite often, then we are left to work on repairing that relationship as best as possible. So it might be looking at a series of facilitated meetings or even professional mediation. Okay, and professional mediation, by the way, is something that professionals are qualified in now. It's not just something that we can do arbitrarily at work. There is, you know, a really clear process for it that, as I say, people do go off and get qualified for and hold certificates in. It's a service you can invest in, and certainly if we're looking at people who really might have been exploited on the grounds of gender, or people who have got really long service and are thinking, you know, about having to leave, and you're worried about constructive dismissal, investing in mediation is a really great precautionary measure that tribunals pay a lot of respect to. So I'm afraid I've whittled on. I've not got time for any questions in this webinar, but if you do have any, then clients, please do contact us in the usual way. We're always pleased to hear from you, and we do really like helping. It's why we're here. So please do pick up the phone. If you aren't a client with us already, but you do want to ask a question, then please send them through to enquiries@hrsolutions-uk.com. In respect to this webinar, I would be happy to answer some initial questions for you, but we do also have a telephone number there for you, and a website where you can check out our services if you're interested in getting any longer term advice, be it with a particular case as a one-off, you know, or any long-term support. So there's our contact information for you. If you have any feedback, do let me know. I like to make sure that I'm tailoring this to what you want to hear and see. And lastly, thank you all very much for attending. It's been a pleasure, and I hope you all have found it useful. So thank you, take care, and goodbye.